I declare open this public hearing of the Parliamentary Joint Committee on the National Anti-Corruption Commission, primarily for examination of the following annual reports: the National Anti-Corruption Commission Annual Report 2023-24 and the Inspector of the National Anti-Corruption Commission 2023-24. I begin by acknowledging the traditional custodians of the land on which we meet, pay our respects to their elders past, present and emerging. These are public proceedings being streamed live via the Parliament website, and a Hansard transcript is being made. Before we begin, a brief word on the role of the committee. The functions of the committee are set out in section 177 of the National Anti-Corruption Act 2022, and these include examining the annual reports of the Commission and the Inspector. The committee also has a role in relation to reviewing the budget and finances of the Commission. This hearing is also an opportunity for the committee to undertake more general functions under section 177, including monitoring the performance by the Commission and the Inspector of their functions and examining trends and changes in corruption among those subject to the Act. Before the committee starts taking evidence, I would like to remind all witnesses that in giving evidence to a committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The committee generally prefers to give evidence in public, but witnesses who have the right to request to be heard in a private session if required. If a witness objects to answering a question, they should state the grounds upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the grounds which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. We have set Friday the 6th of December 2024 as the date for responses to any questions that are taken on notice. And I would like to welcome the Honourable Paul Brereton, Commissioner of the National Anti-Corruption Commission, and senior officials. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. What I would like you to do now is state your full names and the capacity in which you appear for the Hansard. And I will also, just before you do that, state that the committee members in the room have authorised the media to be in the room. So we can start with you, Mr. Brereton.
Paul Brereton, National Anti-Corruption Commission.
Nicole Rose, Deputy Commissioner.
Kyla Kilgour, Deputy Commissioner.
Philip Reid, CEO.
George Philip Devet, General Manager, Enabling Services.
And we also have online
Ben Gauntlet, Deputy Commissioner.
Thank you very much. We will go to questions. We have about an hour and a half with you. Do you wish to make an opening statement, Commissioner?
I did propose to, Chair, if I may.
Please go ahead.
So, thank you, Chair, Senators and members, for the opportunity to make an opening statement on the public record to assist you in your consideration of the Commission's annual report for 2023-2024. First, may I acknowledge my colleagues who are present today to assist the committee: Deputy Commissioners Ms Nicole Rose and Ms Kyla Kilgour in person, and Dr Ben Gauntlet by audio-visual link, Chief Executive Officer Mr Philip Reid, and General Manager Enabling Services Mr George Philip Devet. This week the Commission is 73 weeks old. In the context of our 2023-24 annual report, I'd like to highlight some of the most significant activities, achievements and developments of our first year. We've established from the ground up a brand new Federal Integrity Commission, growing from 149 staff at commencement to approximately 230 staff today. We've opened and occupied 3 new office premises, and we're now established across 5 capital cities. Initially, our operational efforts were focused on receiving and assessing reports of corruption. Increasingly, as these referrals have been triaged and assessed, our main effort has shifted to the conduct of investigations. In our first year, we received 3,189 referrals. This has since risen to over 4,200. We've established processes for the triage, assessment and, where appropriate, investigation of referrals of corruption issue. About 85% are excluded at the triage stage because they don't concern a Commonwealth public official or don't raise a corruption issue. Currently, we're conducting 35 preliminary investigations to help us decide whether there is a corruption issue and, if so, whether and how to deal with it. Another 17 preliminary investigations have been concluded. All but 2 found that no corruption issue arose. The other 2 transitioned to full investigations. Currently, we're conducting 29 corruption investigations, 6 of them jointly with other agencies. We've closed 1 joint investigation with a decision to take no further action when it became clear that corrupt conduct would not be found. We referred 16 matters to other agencies for investigation or consideration. In about 90% of the cases that passed triage, we decided to take no further action, typically because there were insufficient prospects of finding corrupt conduct, or the matter was already being adequately investigated by another agency, or a corruption investigation wouldn't add value in the public interest. We obtained 39 search warrants, 19 telecommunication intercept warrants and 13 surveillance device warrants. I approved 1 controlled operation authority. We issued 16 directions to agency heads to produce documents or information under Section 57 and 157 notices to produce under Section 58. We've conducted private hearings in 7 investigations involving a total of 26 witnesses. We've conducted operations in every state and territory except South Australia. Convictions have been obtained in 6 matters that transitioned to us from the former Australian Commission on Law Enforcement Integrity. Other matters remain before the court, including one in which a Commission investigation earlier this year, supported by the Australian Federal Police, over a period of 10 days and using a variety of techniques, resulted in the arrest and charging of an employee for soliciting a secret commission to facilitate the award of a lucrative contract. I'll elaborate on that in a moment. In our corruption prevention and education work, a critical part of our function in enhancing integrity in the Commonwealth, in our first year we delivered 125 presentations and engagements to parliamentarians, Commonwealth agencies, professional associations and civil society. Since the 1st of July 2024, we've delivered a further 64. We also planned the first Commonwealth Integrity Survey, which we administered in August and September of this year. Around 60,000 public officials responded, and the results will be used to assess corruption risks in the Commonwealth public sector, to identify potential corruption vulnerabilities, and to inform corruption prevention and education initiatives. With the support of the Tasmania Police Academy, we've established a bespoke authorised officer training program unique to the Commission that delivers training to our operational staff. This involves modules on the use of force, search warrants, evidence seizure and handling, and operational safety. All this culminates with practical assessments conducted in real-life search warrant scenarios so that everything is put into real-time practice. To date, 80 of our 91 authorised officers have completed this training since the first pilot in December last year. Of our 29 current investigations, 6 relate to former or current parliamentarians, 3 relate to former or current parliamentary staffers, 5 relate to contractors or consultants, 7 to senior executive officials, and 8 to law enforcement officials. 8 involve procurement, 1 involves recruitment, 4 involve corrupt conduct at the border, 4 involve law enforcement misconduct, and 3 involve grant schemes. Many fall in multiple categories, others fall in none of those categories, so they won't add up. It's also important to remember that most corruption investigations do not result in a finding of corrupt conduct. 2 that I will mention are Operation Kingscliff, which involved an investigation into whether a senior executive service official facilitated the transfer of the partner of a close relative from another agency to a position within the official's department for the benefit of that person and the close relative. The department made a mandatory referral to the Commission. The Commission opened an investigation as it was satisfied that if established, the conduct could constitute an abuse of office, having regard to the seniority of the official and the nature of the conduct, it could be serious. Using compulsory processes, we obtained and examined the documentary record of the recruitment and communications between the person of interest, the relative and others. There was a comprehensive examination of departmental records, the use of digital forensic techniques and compulsory private hearings in which witnesses, including the POI and the relative, were examined on oath to elicit the facts. The POI has since resigned. Operation Pelican involved an executive procurement manager overseeing a multi-million contract for facility management for a Commonwealth entity, allegedly asking the managing director of one of the tenderers for a percentage of the contract value in return for an assurance the company would be awarded the contract. The intended recipient of the bribe reported the allegation to the Commonwealth entity's executive, and the following day the entity reported the matter to us and to the AFP. We opened a joint investigation with the AFP, and over a 10-day period the matter was investigated using a variety of tactics, techniques and procedures. The POI was arrested after a controlled operation and was charged with soliciting a corrupt commission contrary to Section 249B of the New South Wales Crimes Act. Our first year, of course, has not been without challenges. Challenges are inevitable when establishing a new anti-corruption agency, including establishing fit-for-purpose IT and document management systems and processes. Anti-corruption commissions have always generated controversy, and by the nature of their work, they always will. First, we recognise that there's work to be done in educating the public on our role and the legislation within which we operate, and we're committed to doing this. How the Commission explains its processes and investigative choices is important. But the Commission is an anti-corruption commission concerned with serious and systemic corruption in the Commonwealth public sector. We're not a complaints handling agency, an employment or discrimination dispute resolution service, or an administrative decisions review authority. Making a referral to us is not like making a referral to the Ombudsman or an application to the Administrative Review Tribunal. We don't adjudicate on individual complaints. Referrals to us aren't individual initiating processes on which a referrer is entitled to an adjudication, but a source of information that, with other information, can help us to identify and decide what we should investigate and where we should focus in the public interest to have the optimal impact in deterring and preventing corrupt conduct. Often that means we will focus on matters which are not and have been the subject of investigation by other agencies, rather than those which have been or are under investigation elsewhere. We understand that individual referrers who feel they've been treated unfairly and insensitively by a public official or a Commonwealth agency can find this challenging to accept. But there was no limitation period placed on referrals to the Commission, and that means that a small number of referrals relating to historical events have occupied a considerable amount of Commission resources. Secondly, there have been calls for us to provide more information about our activities, for public hearings, and to produce outcomes publicly and promptly. Of course, we work within the legislation we've been given, which requires that ordinarily our proceedings be conducted in private. That was chiefly to avoid the risk of unfair and premature damage to reputations that can be caused when unproven allegations of corruption are publicised. In accordance with the legislation, we will conduct public hearings where the circumstances and the public interest justify an exception to the general rule. When the legislation comes to be reviewed, we'll provide submissions on the question if our experience indicates that change is needed. But it is important to remember that our hearings are fundamentally meant to be a means of gathering evidence and information. Unlike a criminal or civil court, we can compel witnesses to incriminate themselves, and it is a large step to do that in public where the usual protections don't apply. And many witnesses, particularly whistleblowers and people in that category, are more comfortable and give more helpful accounts if they can do so in private than in public. In addition, investigations rarely benefit from publicity. Publicity has the potential to compromise the efficacy and fairness of investigations. It limits investigatory pathways, particularly the use of covert powers. It alerts persons of interest, enabling the destruction and distortion of evidence. That's why investigatory agencies generally don't talk about their operations, and in that respect we're no different. But to provide as much transparency as we can, from the very earliest days, we have each week published statistics about the number of referrals, assessment investigations. More recently, we've provided additional information, as I have today, about the general nature of investigations by the type of person and conduct involved. At the conclusion of an investigation, we can publish our reports if satisfied that it's in the public interest to do so, and I've said that we will usually be disposed to do so, especially if a finding of corrupt conduct is made or where it is appropriate to clear the air of an unfounded allegation. Thirdly, in early October we published a public release version of our report on Operation Bannister, which concluded that a former Home Affairs official who had received payments from a close relative who was a principal of Paladin had not engaged in corrupt conduct. In some places this was misreported as that the National Anti-Corruption Commission had cleared Paladin of corrupt conduct. We did no such thing. We chose to publish the report chiefly to clear the air of the allegation about the former Home Affairs official. The investigation was opened and completed by the predecessor agency Ackley before the 30th of June 2023. The issue investigated by Ackley was the conduct of the former Home Affairs official, not the conduct of Paladin. It's a matter of public record that there is a separate AFP foreign bribery investigation into Paladin. Ackley concluded before the 30th of June 2023 that there was no corrupt conduct by the official in question. Because the investigation had not been reported on by Ackley, responsibility for reporting on the already completed investigation transitioned to us. We reviewed the evidence and came to the same conclusion. The evidence, in fact, demonstrated convincingly that the official was not in a position at the relevant time to provide any relevant information or exercise any influence to advantage their relative in Paladin and could not have done so. Finally, I turn to the issues associated with the Robo-debt Royal Commission referrals. At the outset, I would emphasise, as I stated in my foreword to the annual report, that since commencement, we have been committed to carrying out our work in good faith, with integrity and in the public interest. That doesn't mean that our decisions will always be popular. Often they will not be. Making decisions that we believe to be right, though they may be unpopular, is what integrity requires us to do. Integrity also requires that we acknowledge and own our mistakes, and with regard to the inspector's report into our decision not to investigate the Robo-debt Royal Commission referrals, I have done so and we have set about to make it right. I have accepted that, viewed through the lens of the legal notion of apprehended bias, I've been found to have made a mistake for which I am solely responsible. Given the need to ensure that there is public confidence in the process, we decided that the original decision should be reconsidered by an eminent independent person, and in this way the mistake will be rectified. We've also amended our conflict of interest procedures in relation to the consideration of referrals at the Senior Assessment Panel, so that the option of a person who has declared a perceived conflict not being the ultimate decision maker but otherwise participating in the process has been removed. Today I'm not going to canvass the original decision as it is to be independently reconsidered, but in the light of some of the public commentary, I will say something to illustrate that the decision was reached after careful and mature reflection, and I'll also say something about the inspector's finding. The first significant step after the referrals were received in early June 2023, was to ask our lawyers for an opinion as to whether the conduct described in the referral from the Royal Commission, if proven, would fall within the definition of corrupt conduct so as to give rise to a corruption issue. Over about 6 weeks, from late July until the end of August 2023, our lawyers produced a comprehensive legal advice on the question and associated considerations. Next, the referrals were considered by our assessment section. First, they were considered by an assessment officer and then reviewed by the Director Assessments. Comprehensive assessment summaries were produced for consideration by the Senior Assessment Panel. The Senior Assessment Panel considered the matter on the 19th of October 2023. At that meeting, a decision was made to take no further action in relation to person 1, 2, 3, 4 and 5, who were public servants or former public servants, but to look further at person 6. Over the next few months, Deputy Commissioner Gauntlet, at times working with our legal team, in addition to his other duties, considered whether the Royal Commission evidence relating to person 6 was incomplete and whether it was likely that we would be able to gain further evidence. In the course of that, he and Deputy Commissioner Rose consulted with a senior official of the Royal Commission. Ultimately, that work was completed on the 28th of March 2024, and with the benefit of Deputy Commissioner Gauntlet's report, Deputy Commissioner Rose, in consultation with our lawyers, prepared her decision record, which was finalised on the 16th of April 2024. We then went through a procedural fairness process with the referred persons because we were going to publish a statement, and so we gave them an opportunity to comment on the statement we proposed to publish. As you know, last month the Inspector published a report finding that although I declared a perceived conflict of interest and managed it by delegating decision-making to Deputy Commissioner Rose and excused myself from the meeting when the decision was to be made, that was insufficient to avoid the decision being affected by apprehended bias. That is, the possibility that a reasonable observer could think that the decision was possibly not impartial on account of my involvement in some parts of the process. My involvement, in the words of the statute and the finding, though not unlawful, arose from a mistake of law or fact as to the extent to which the principles of apprehended bias required me to be isolated from the process. Any mistake of law or fact is within the definition of officer misconduct, and so that finding inevitably followed. The key finding is at paragraph 116 of the Robertson report on which the Inspector's report relies. Mr. Robertson says that the steps taken by me to manage the conflict arose from a mistake of law, as natural justice required me not to participate at all in the decision-making process with respect to referred person 1. It was conduct which, though not unlawful, arose from a mistake of law, and he concluded, as I have said, the mistake of law was as to what the law required to be the action taken in consequence of the Commissioner declaring his interest. On this analysis, there has been officer misconduct as defined in section 184. The finding depends on the finding of a mistake of law, which are professional inevitabilities for judges, tribunal members and administrative decision makers. There is no suggestion of actual bias, nor of any intentional impropriety. There is no reflection on my integrity. The mistake is characterised by the Inspector as an error of judgment. Importantly, there is no criticism of Deputy Commissioner Rose, who actually made the decision. We accept that the ultimate conclusion in the Robertson report is open, and it is in the public interest that we should accept it and have the original decision independently reconsidered, and that's what we're doing. But you're entitled to an explanation as to why I did remain involved to the degree I did. Although I considered that I'd be able to make an impartial decision, I nonetheless recognised that some might think my impartiality could be affected by my prior professional association, not as some have suggested a close personal friendship, with one of the 6 persons referred. So I declared a perceived conflict and recognised that measures had to be put in place to ensure that the decision was not influenced by it. On the other hand, the Robo-debt Royal Commissions were received in the first week of our existence, while we were just establishing our processes, policies and procedures for our work generally. The referrals involved several legal and policy questions for the first time, including the scope of our jurisdiction and the meaning of corrupt conduct in the Act. They would also have very significant resource implications for the Commission. These were matters for which I, as Commissioner, had ultimate responsibility. I considered that it would have been irresponsible and negligent for me, as a leader of the organisation, to abandon any involvement in them, provide no guidance, walk away, say it was not my problem and leave everyone else to their own devices. And in those circumstances, having regard to the nature of the conflict, that the decision was to be made was not a quasi-judicial decision as to whether someone had engaged in corrupt conduct, but a preliminary decision as to whether an investigation should be opened. And having regard also to the status of the delegate, Deputy Commissioner Rose, with a significant history of independent decision-making, who was given no direction as to how to exercise her delegated power, and whose appointment as a statutory officer could not be affected by me, I considered that an appropriate balance could be achieved by delegating decision-making responsibility to her and by excusing myself from the meeting when it came to make the decision so that it could be made freely and all, if they wished, could speak freely in my absence.
Commissioner, I'm just going to say we're coming on to half an hour now and the committee has questions.
I know the committee has questions and, Chair, I've very nearly finished what I need to say. I accept that my judgment in that respect has been found to be mistaken through the prism of the law relating to apprehended bias, but at the time I had to strike a balance between my responsibility as a leader and, on the other hand, avoiding the perception that my prior professional relationship could affect the decision. Having accepted that I got the balance wrong, we're now setting about putting that right through having the decision independently reconsidered. And finally, Chair, I would like to record 2 notes of appreciation. First, to my colleagues, the statutory officers and above all the staff of the Commission in all its branches and offices. They work incredibly hard with great commitment to the Commission's important functions, including in highly stressful circumstances and with distressed individuals and in emotional circumstances. Our investigators are mastering highly complex cases, some involving hundreds of thousands of documents. Our frontline staff deal professionally and sympathetically with many members of the public, some of whom are understandably emotional and distressed. They can and do review enormous amounts of information, some of which is extremely complex and detailed, with great aptitude and resilience. I am proud to lead them. But I also acknowledge the many individuals who've provided referrals to the Commission. Some of these referrals are deeply personal and reflect particularly challenging life circumstances. Others reflect a deeply held concern as to the public affairs of the Commonwealth. The Commission's efforts, as with all corruption and integrity commissions, will take time to show a clear and tangible ongoing public benefit. But without these referrals, some potentially serious and systemic corrupt conduct would be ongoing and in some circumstances affecting whether some Australians receive essential services. Even though not all of those referrals result in a corruption investigation, all of them add to our understanding and intelligence. And so I would like to thank all who have done so for taking the time to ensure we can investigate corrupt conduct that would otherwise go unnoticed. Thank you very much, Chair.
I will just note that given we're half an hour in, we will extend the program to enable senators to ask the questions that they need to ask. This is a very important body, one that many people in this parliament and outside of it have worked tirelessly to stand up. I'm very proud to see that in 2022 when the Attorney-General introduced the legislation to establish the NAC, and many people on this committee have done a spectacular job in building it to the point of being able to stand it up in a manner that enabled it to be powerful enough to investigate ministers and parliamentarians, transparent enough, independent enough. And I think one of the clear problems that we're grappling with at the moment is the balance of transparency, independence, people's expectations. So our questioning here may be quite robust. As I always do at the opening of a hearing, I will ask people to be respectful both in the asking of their questions and in the responses to those questions. This is a critical point. This is a first public hearing of the National Anti-Corruption Commission, and I know that there is a great deal of interest in understanding how it is operating and questioning into some of the operations of the Commission. It is this committee's role, quite simply, to look at how well both the Commission and the Inspector are operating, how well they are serving their purposes, and we are here to assess those operations so that the Australian people can have confidence in the power and the scope that the NAC has been given and the power and the scope that the Inspector has been given. It is not the role of this committee to litigate the decisions of the NAC, but it is reasonable for this committee to look at whether the NAC is operating and maintaining its position of trust to the level that it is expected. On that, I will go directly to my colleagues to ask some questions, and we'll start with the Deputy Chair, Dr Haynes.
Thank you, Chair, and thank you to all the representatives today of the National Anti-Corruption Commission. We've just heard extensively about the initial workload of the National Anti-Corruption Commission. I'm curious, please, Commissioner Brereton, to date, have you felt sufficiently resourced to exercise the agency's powers?
Thanks, Dr Haynes, for the question, which I can answer pretty shortly with a yes.
Can you tell us what your metric is for deciding what is an appropriate amount of resources for an investigation?
At this stage, we have not quite reached capacity in terms of our investigatory resources, but we are very close for it. So it would be fair to say we allocate to an investigation the resources that we think are necessary to conduct that investigation. Typically, there will be a Director of Operations leading it, or a team leader, and a case officer with principal responsibility for it. Often they will have a lawyer supporting it, a digital forensic analyst, and others. But it really varies from investigation to investigation as to what the resources required for any individual investigation are. Some of our larger investigations at the moment occupy pretty much the whole effort of an investigatory team. Some of the others have one person working on them. But if you're asking me, do I need more people to work on what we've got at the moment? The answer is no, we've got enough to do what we're doing at present.
In your speech to the National Public Sector Governance Forum on the 15th of November 2024, you said, and I quote, "The Robo-debt Royal Commission referrals were received in the first week of the Commission's existence. While we were just establishing our processes, policies and procedures, they raised several legal and policy questions for the Commission for the first time, including the scope of our jurisdiction and the meaning of corrupt conduct under the NAC Act. They also had very significant resource implications." Can you explain to the committee what you meant by significant resource implications in regard to that Robo-debt referral?
Absolutely. If we investigated Robo-debt that would likely be a large investigation that would use and require the dedication of a significant part of our resources. That's evident enough from the work the Royal Commission had already done and the amount of resources it required of the Royal Commission. Every time we open an investigation, there is a resource consideration. Is this something we should be looking at in priority to something else? And particularly, is this something that we should be looking at if it has already been looked at elsewhere or is being looked at elsewhere? Should we focus on that, or should we focus our efforts on something that hasn't been and isn't otherwise being examined? So the resource implications, how do we use our resources? Do we focus on new things, or do we focus on things that have already been investigated? That's essentially what it boils down to. If we investigated Robo-debt, there would be other things that we would not be able to investigate.
Am I right in saying you just, in your opening statement, said you have sole responsibility for resourcing of the National Anti-Corruption Commission?
No,
that's your responsibility?
I didn't say that at all.
I apologise.
I said I had sole responsibility for the mistake.
Okay. How much weight did you give possible resourcing constraints in your decision not to investigate Robo-debt? In the course of all the other metrics that you would look at, what part did that play?
Well, since it was Deputy Commissioner Rose's decision, I think I'll offer her the opportunity to answer that.
Thank you.
Thanks, Dr Haynes. You'll see in the Inspector's report on page 12 there are a list of 13 aspects in my decision. Resourcing certainly was one of them, but it wasn't even in the top three. The top three were the fact that there was a risk of inconsistent outcomes. We were quite concerned, as the Commissioner said, and you might want to go back to that part of your question, about at that stage we were really looking at the definition of corruption and what serious and systemic meant, and therefore what we would actually take on and what we wouldn't. We actually had serious concerns, and the legal advice raised that we may actually not be able to reach the threshold of corruption on the information that we had, and we were quite concerned that we would commit a great deal of time and resources and raise the hope of victims and their families that there would be a process with an outcome that we may not reach. So that was one of the most important considerations. Another one was that we wouldn't be able to obviously provide any individual remedy. Of course, we could find people corrupt, which has meaning in itself, but there'd be no other individual remedy. There wouldn't be any punishment, fine, or other outcome that we could deliver. And we felt that if there was an entire Royal Commission set up and a great deal of resources given to investigate the Robo-debt matter, nearly 1 million documents that the Commissioner went through, that we would be unlikely to add any further value or find any other evidence. And we did some investigative work in the background to actually see if the Royal Commission themselves thought that there were things that we may be able to uncover, and they didn't believe there was. They felt that they had all of the evidence, but there wasn't evidence there that could assist us. So they were probably the top three.
So am I right to saying that resourcing really played very little part in that decision?
Well, resourcing certainly was a consideration because we knew how much time, money and effort, of course, the Royal Commission had put into it. And if we were going to liken the type of investigation to a second Royal Commission, when we only...
But it wouldn't be a Royal Commission, of course, would it?
No, but we are set up with very similar powers.
Indeed you are.
Yes. Yes, so to be running a similar investigation, there'd be many things that would have duplicated what the Royal Commission had done and done very well. Resourcing at that stage, and it was in the first couple of months, we didn't know how many referrals we were going to have. I was personally quite shocked by how many referrals came in, and the fact that we've had over 4,000, I think, at the moment. It shows that it doesn't seem to be slowing, and we are, as the Commissioner said, just about full on the investigatory front. And if we had have taken on Robo-debt, there will have been investigations that we wouldn't have progressed or maybe would have asked other agencies to do. So it was a consideration, but it certainly wasn't the primary consideration.
Could I just put to you, though, that one of the functions of this committee is to ensure that you have the resources you need in order to fulfil your functions. Did it occur to you that you might come to the committee to express concerns that this was potentially a complex, well indeed it would have been, a very complex investigation to undertake? You were at the beginning of the life of the National Anti-Corruption Commission, and perhaps there would be a greater need for increased resources.
At the time, Dr Haynes, no, that wasn't something that I had considered, but the Commissioner and CEO may add to that. It's certainly something that we may now need to consider if the eminent person does believe that these should be investigated and that we have to find investigators to undertake that. I suspect, but as I say, that's not my area, that's the Commissioner and CEO. I suspect that we may come back before the committee to discuss resourcing then.
Maybe the CEO or Mr Brereton could add to that answer.
So, to begin with, I think you need to understand that we are a standing Royal Commission. So
I understand that
good,
very clearly.
On top of that, 16 months in, we're still growing as an organisation, maturing as an organisation. We have not hit our ASL level as yet, not in its first year. And we may not hit it in the second year because of the nature of recruitment activities. They take time, specialist skills, at times hard to find. So we're building an organisation as we're running investigations, doing assessments, running investigations, doing the corruption prevention education work. And so that's a challenging environment to be operating in and to receive significant numbers of matters on day one and significant matters in the first week. Certainly didn't make it any more straightforward for us in developing the organisation's capacity and capability, and that's still an ongoing program. We were $500,000 underspent in the last financial year. We're tracking underspent at the moment, so it's not a money issue. It's about people and their ability to do the job. And how many investigations? 29 investigations that are underway. 35 preliminary investigations. That's a lot of work. We are very investigator heavy in the organisation. That's part of the structure. But there's always going to be a limit. And having been the CEO of ICAC for 5 years, it's always a fundamental element of the work of these sorts of organisations. Which matters can you look at? Which matters do you refer back to others? Which matters do you decide to take no action on? And ultimately, we have to make those decisions. And even if you had double the number of staff, it doesn't mean that it would make it any faster or easier. It would just mean that you'd probably take on more matters.
Did you want to follow up? I've got some more questions, Chair, but did you want to follow up on that question?
I think the thing that's coming up regarding the Robo-debt decision quite a lot, to me anyway, is the fact that the Royal Commission referred it directly to you, believing that you would be able to do something else.
I don't think that's an accurate characterisation with respect.
I think what I'm saying, Commissioner, is this is what is being put to me by constituents, by Australians out there on the street who are concerned. So I'm asking.
So the Royal Commissioner referred it to us for consideration, like the Royal Commission referred matters to the police for consideration, and like all Royal Commissions typically refer matters to prosecuting and other authorities for their consideration. It doesn't involve an expectation that the referred body will necessarily do something. We commonly refer information we receive to other agencies, to police forces, and that I can say, we've received this information, it may be of interest to you. But that does not involve an expectation that they will actually do something. And yeah, I agree there may be a perception that because the Royal Commission referred it to us, therefore we should do something. But a Royal Commission referral to us is no different to any other referral to us. It's then for us to consider whether we're going to add value in the public interest by doing something.
Thank you. I do need to rotate.
Okay.
Mr. Wallahan, we'll go to you next if you have questions online.
Thank you, Chair, and thank you, Commissioner. There is a question about public trust in this new institution. What is your opinion on the state of public trust in this institution, and what role do you see for this committee and the Parliament in restoring that?
So, I'm frankly not as pessimistic about the current position of public trust as some are. I agree that there are some sectors and segments which do not have trust in the Commission. I think they are probably segments that may never have really been inclined to trust the Commission. But there are certainly some that do not have trust in the Commission. To the second part of you, but I think by and large, and we see this in the volume of referrals that continue to roll in and the responses we get in our engagement activities, I think there is a good level of trust and confidence in the Commission more generally. But as to what this committee and the Parliament can do, the answer to that is by expressing confidence in and support for the work of the Commission. We have told you today, a lot of it's in the annual report, but we've told you today what we are doing. And there are people sitting at this table at the moment who are part of the Commission partly in response to Robodebt, who were motivated to come here because of Robodebt and improving integrity in the Commonwealth. That's what we're all trying to do, and public support for what we are doing from the committee and from the Parliament would go a long way to reinforcing public trust, I think.
Can I suggest one area that may help, and can I seek your help in this? The term apprehended bias is one familiar to those who are involved in litigation and the courts. Most Australians aren't. You have been a Supreme Court judge, a Court of Appeal judge. Could you explain in layman's terms what apprehended bias is, how frequent it is, and your experiences of that as a judge?
Look, I did have some words, I think, in my opening statement that sought to explain it, and I'll see if I can bring them back. But apprehended bias is not about actual bias. Apprehended bias is a legal rule that involves it's called the double might test. So it's concerned with the possibility that a reasonable observer might think that the decision might not be impartial on account of some interest or association of the decision maker. And perhaps a really useful thing to turn to is something that the High Court said quite a few years ago about that in the case called Livesey and the New South Wales Bar Association, which we did refer to in our submissions to the inspector. Thank you very much, Carly. So what the High Court said was that, well, let me say that the question of, it turns on whether the circumstances would give rise to that situation that the reasonable observer might think, could possibly think, that the decision maker could possibly not be impartial. And about that, questions of judgment often differ, and the High Court said in Livesey that the fact that an appellate court, and here I would say the inspector, concludes that on account of apprehended bias a trial judge ought not have sat, does not involve any personal criticism of the judge or any assessment of their qualities or their ability to have dealt with the case fairly and without prejudgment or bias. Now, I have been trying to get that message out, probably in too technical words in some of what I've been saying, but that's what it's about, and that's what the finding means.
And how common is it?
And how common is it for judges to, in their careers, to have had those applications and findings made against them?
Look, I would be surprised if there is a judge who hasn't had, if there's a Superior Court judge who hasn't at some stage had to deal with an apprehended bias situation.
Thank you, Commissioner. The other area that is commonly raised, and again, I'm seeking your assistance because there are many people watching this who are normally engaged in the processes of this institution. You are the National Anti-Corruption Commission, not the National Anti-Incompetence Commission or Malfeasance Commission. Can you again, in layman's terms, tell us the difference between corruption versus malfeasance or incompetence? What are the key differences between those?
I tend to use the word maladministration to distinguish even negligent administration from corruption. The key thing about corruption, I think, is that there's almost always a personal benefit involved. The general lay definition is that it's an abuse of entrusted power, in our context, entrusted public power, for a collateral private purpose. But it involves the idea of an abuse of power, and it involves the idea of a collateral or private purpose. That's what makes something corrupt, when you're using your public position to advance some private agenda and not for the public purpose for which the power was given.
And how important are the requirement for a benefit or a detriment? Can you just give us an example of where that would occur or not occur?
So there are two important parts of the definition. One is breach of public trust. So in breach of public trust, the real test is the purpose. Public powers are conferred on public officials to be exercised for the public benefit, not for a collateral purpose. So under the breach of public trust part of the definition, the essential feature to make conduct corrupt is the purpose for which the power is exercised. If it is not exercised genuinely for the purpose it was given, but for some collateral purpose, that will be corrupt conduct. The second part is the abuse of power part of the definition, and the abuse of public power essentially involves the intentional use of someone's power or position to confer a benefit on themselves or someone associated with them, or to inflict or to improperly inflict a detriment on someone else. So in the abuse of power, the benefit or the detriment is a critical part of the concept. In the breach of public trust, it's the collateral purpose, the improper purpose, that is the important part.
Thank you, Commissioner. And final question is around the key differences between this as a national institution and the state institution. Could you please address how you have navigated your responsibility and jurisdiction over national security agencies, the Australian Defence Force, and how you have dealt with the public hearing test with those institutions in your jurisdiction?
We've had a couple of national security community matters, none of which have reached the stage of a full investigation. And we have a couple of defence matters, I think one of which is at the stage of a full investigation and a few that are at the preliminary investigation stage. I might not be precisely right on that. At this stage, security issues have not of themselves been a reason for not conducting a public hearing. We haven't got to the stage of saying, but for a security issue, we would conduct a public hearing if that's the question you're looking at. We haven't got to the exceptional circumstances test in any of those matters yet.
And sorry, I know I said final question, Chair, but just one quick one. This is a unique institution in the world. I think other than Hong Kong, historically, that there hasn't been many others. What sort of interest has there been from other democracies around the world in this institution?
From very early on, I have been conscious of wanting to position us as a leader, not just nationally, but internationally, in anti-corruption efforts. And from the international perspective, my focus has very much been on the Pacific and particularly the Southwest Pacific, because I see the anti-corruption effort and the national security effort going hand in hand with Australia's interests in that part of the world. And so I have participated in a number of international fora, including the 10th Conference of State Parties to the United Nations Convention Against Corruption in December last year, and the International Association of Anti-Corruption Agencies in Hong Kong this year. And in both of those fora, there has been a great deal of interest in our establishment, our work, and we have played a fairly prominent role in those fora.
Thank you, Commissioner. Thank you, Chair, and thank you all.
Thank you. We'll go to Senator Shoebridge.
Thanks, Chair, and thanks all for your appearance today. Commissioner, you said that you would expect or like this committee to express confidence in the NAC. Do you remember saying that?
In answer to a question as to what the committee or the Parliament could do to assist in public trust in the NAC, I said it could express confidence.
You accept that's not our job, though?
Absolutely. I'm responding to a question as to what you could do, and I totally accept that's not your job.
And indeed, it's our job to, amongst other things, monitor and review your performance, correct?
That's what the statute says.
It is. And in doing that, do you accept that there is significant public concern about your role in the Commission's dealing with the Robo-debt referral?
I don't know how significant or how widespread that concern is. I accept that there is concern expressed in some quarters.
Well, you say some quarters.
Yes.
Do you not accept what I would have thought is a fundamentally apparent proposition, that there is widespread disquiet about how the NAC has handled the Robo-debt referral? Do you not accept that there's widespread disquiet?
Senator, I accept that there is disquiet in some areas. I'm not prepared to accept that it's widespread.
You referenced the finding of Mr. Robertson, SC, I think in paragraph 116 of his report to the inspector. And just to be clear, he said this: I have found that the steps taken by the Commissioner to manage his conflict of interest, that conduct arose from a mistake of law, as natural justice required the Commissioner not to participate in the decision-making with respect to referred person 1. He was right, wasn't he?
I have accepted that the view is open. I think other views are also open, but I accept that the view expressed by Mr Robertson is open and that it is in the public interest that we accept it and move on.
But you don't accept it's right, do you? You say it's open. I think you said you've been found to have engaged in this, but you're very careful in your language, and at no point have you ever said that you accept it was right. And I'm giving you that opportunity now. Was Mr Robertson right?
I have said in an earlier answer today that views about apprehended bias differ between people. I have had different views expressed to me, and I'm not going to agree with the view that Mr Robertson has expressed, but I accept it as an open view and that it is in the Commission's interests that we accept it and move on.
Who has expressed different views to you?
I'm not going to go into detail about individuals.
You put it forward as a way of justifying your position. So
okay,
who
we're
has
not
expressed
going to talk over each other.
Who has expressed those views to you?
I do not wish to disclose the identity of people who have spoken to me in private and confidence.
Well, I'm pressing you. Unless you have a public interest immunity basis to not say that, please answer the question. I'm not going to disclose who has said to me that they think different views are open. Commissioner, you are the Commissioner of the National Anti-Corruption Commission. And if you are having private conversations with people about your role, and you put that on the record here, and you're not willing to say who you're having private conversations with, that raises very real concerns for transparency. So I give you the opportunity again, Commissioner. Who have you been having private conversations with about your conflict of interest in the NAC?
I'm not having private conversations about my role, but I do, believe it or not, have friends who, from my past, who might ring and offer a view. You
put those opinions forward in order to justify your position in your first answer to me, Commissioner, and I'm now asking you, I'm testing you on your justification and you're refusing to answer. Who is it you say who backs you in on your position?
Chair, I do not wish to disclose private conversations that I have had with friends.
About your statutory role?
Not about my statutory role.
Senator Shoebridge, I feel that the Commissioner's expressing some views about conversations he's had. Can I just confirm you're not... This is kind of a line ball. Like, of course, your private conversations are your private conversations. If you're bringing them in here as a source of evidence, then we're kind of edging down there. But if that's not what you're doing, and if you could just clarify...
I am not seeking to use them as a source of evidence, and I will not rely on them for that purpose.
Thank you. Senator Shoebridge.
You still have a role in the Robo-debt referral, don't you?
If you mean that I have to appoint a... if I have to make a delegation, then I have the role of making a delegation which only I can perform. Mm-hmm. However, there are a number of things to be said about that. There are multiple steps in this process. Because of the procedure we're adopting, 2 separate appointments have to be made. First, they both have to work for the appointment to work. The Chief Executive Officer has to appoint the selected person as a temporary staff member. That is something that is totally within his function and that I have no part of. And that appointment is made by the Chief Executive Officer, who has no conflict. The delegation under Section 276 can be made and can only be made by me, and the inspector's recommendation is that I make that delegation, and I will do so. But I can only do so to a person who has been appointed by the Chief Executive Officer. Thirdly, although I must make that delegation and only I can make it, I am not doing it unilaterally, but I am consulting all of the Deputy Commissioners about it.
So you're going through a process of consulting with the Deputy Commissioners. Who's putting forward the names of the eminent person that you're then taking to the Deputy Commissioners?
The names were sourced from a list of persons engaged for complex work by the Australian Government Solicitor.
And you're taking that list of names to the Deputy Commissioners and consulting with them, is that correct? Or are you taking a subset of those names to the Deputy Commissioners?
First of all, the Australian Government Solicitor approached the people or a number of people on the list to see if they were interested and willing to undertake the assignment. Once those who were willing to undertake the assignment were identified, the Deputy Commissioners and I discussed them, but it's a very short list and there was not much to be discussed.
So, I ask again, did you at any point choose a subset of the list, or did you take everybody on the list that had been identified and found willing to participate?
I did not choose a subset.
Mm-hmm. And you're continuing to have discussions, are you, with the Deputy Commissioners about the selection of the eminent person?
Well, that process is very well advanced and the Deputy Commissioners have been as involved as I have been in that process.
Do you accept you now have two conflicts of interest in the choice of the eminent person?
Well, first, Senator, I don't think the question of conflict of interest in the appointment, in the delegation, I don't make the appointment of the person as a staff member. That has been made by the CEO. In respect of the delegation, the question is moot or hypothetical because only I can make that delegation.
Mm-hmm. Do you accept that you have your initial conflict of interest in relation to referred person one, and I think you've described that in multiple different ways? Do you accept that that remains a conflict of interest?
Not in relation to the appointment, or not in relation to the delegation to a person who will be appointed by the CEO.
Mm-hmm. Do you accept that there is an institutional conflict of interest which lies at your feet as the head of the institution, insofar it would be preferable to the institution and your own reputation that the eminent person agreed with your initial determination?
No, Senator, I have no interest in the eminent person agreeing with or disagreeing with our original determination. The only interest I have is that an independent person review the material and make an honest, independent decision.
You see, Commissioner, I suggest to you, you do have a very clear conflict of interest in that if the eminent person has a position contrary to your decision not to investigate the Robo-debt, that would be deeply embarrassing of you and the NAC, but you don't accept that that's a conflict of interest.
It wouldn't be deeply embarrassing to me since I didn't make the decision in the first place, and that's just not how I and I believe the rest of the statutory officers see the world. If someone makes a decision different to us, I'm I'm used to it. I've been overturned on appeal, and I've overturned other judges on appeal more than many times. And
Commissioner Brereton, you still can't accept the finding of Mr Strickland. You still reject that. You still say it may be open, but you refuse to accept that finding against you.
I think you might have the wrong gentleman.
Mr Robertson, I'll say it again. Commissioner, you still don't accept the finding of Mr Robertson SC. You still refuse to accept that. How do we take that in light of the answer you just gave?
I have said repeatedly that I accept it, though I do not agree with it.
Well, no, that is the first time you said it in those clear terms. You've previously said it was open, that you accept it, but now
Yes,
we have you, and I appreciate the frankness. You don't agree with it. Why don't you agree with it?
First of all, because minds differ as to whether circumstances give rise to a reasonable apprehension of bias. I don't think these circumstances did so, but others have a different view, and I accept that different view is open, and I therefore accept the Commission has accepted the decision.
Commissioner, there is significantly
Last question,
more
Senator Shoebridge.
I wish to take you to test your position rejecting Mr Robertson's proposition, but I might just put this to you. Mr Robertson, in paragraphs 101 and 102 of his report, said the Commissioner's involvement in the decision-making under Section 41 was comprehensive before, during and after the 19 October 2023 meeting at which the substantive decision was made. The views the Commissioner expressed at the meeting on 19 October 2023 were not limited to policy questions concerning the referrals generally, as the policy questions had a strong factual element specific to, amongst others, referred person 1. The discussion was framed by the issues raised by the Commissioner. The Commissioner settled the minutes of the 19 October 2023 meeting. Commissioner, Mr Robertson is right, isn't he? And where you say, as you did earlier to this committee, that you're interested in policy and resourcing points, you fail to mention that you expressed views which had strong factual elements to it, including in relation to referred person 1.
I don't accept that I expressed views relating to referred person 1. I expressed views on policy issues which would have implications for all the referred persons, including referred person 1, and that is, I think, what Mr Robertson said.
You see,
We're going to rotate the calls, Senator Shoebridge. I've been trying to do this for the last couple of minutes, just to be fair to all members of the committee. We'll come back to you. Mr Laxell.
Thank you, Chair. Thank you, Mr Brereton. When I talk to people in my community, they approach me and tell me that they've gone from a sense of joy that a federal anti-corruption commission has been created and exists to now profound disappointment about how the NAC has operated since its inception. You've identified in your comments in the annual report that people support the creation of the NAC, that they support the concept of the commission, but many have approached me saying it hasn't delivered to its potential. Why do you think Australians feel this way?
Largely because corruption investigations take time, and it will take time for some of the investigations we're conducting to produce results and show the value of the work we are doing.
What would you say to those people that have expressed these views or feel this way? Just to be patient, I suppose? Is that what you're suggesting?
I would say that we are conducting 29 full investigations at the moment. I've already referred to the preliminary investigations, that some of those are complex and difficult, and that if they want to see results in terms of outcomes of investigations from the Commission, those will take time to produce results. But I think there's something also to be said, and that is I think integrity is on the Commonwealth agenda, on the lips of departmental secretaries, on the agenda of every second meeting around Canberra at the moment. And I think we have a lot to do with that. I think our promotion of the cause and our engagement activities have had a great deal to do with elevating the importance of anti-corruption and integrity issues and the attention it is getting and the attention which officials all around the country are paying to it. And I think that's already a very significant outcome.
You mentioned in your opening statement, I mean, just as an aside, perhaps through you, Chair, or to some of your staff, Mr. Brereton, if at all possible at future public hearings, if you could provide us with a written copy of your opening statement. I did try to take notes as you were reading it out, but I don't want to incorrectly quote you. But you did mention some of the prevention strategies, which you've just referred to. There are 125 presentations and engagements, 64 of something else. And I do note in your report in the forward that you have two main lines of operation, being deterring corruption through detection, investigation, exposure, and preventing corrupt conduct through education and engagement. I guess I'm struggling to understand where the exposure of corrupt conduct has been in your operations to date. How I'm giving you the opportunity to answer this. How are you exposing corrupt conduct?
Through the investigations that we are conducting, which will, when they come to light, expose corrupt conduct, through the prosecutions that are on foot at the moment as a result of the prior Ackley investigations and our Operation Pelican investigation, all of those involve the public exposure of corrupt conduct. When we publish our reports, that will expose corrupt conduct.
Have you considered the commencement of a public investigation yet?
We have, and we have a number of potential subjects for public inquiries under consideration. Frankly, we have got enough work, well, more than enough work coming in through the referrals at the moment that we have considered it important to deal with the bow wave of referrals and manage them before we turn our mind to a more generic public inquiry. But yes, we have and continue to turn our mind to a public inquiry.
How important do you think public inquiries are to undertake your function of exposing corrupt conduct?
Yeah, I think they're an important part of the function.
Mm-hmm. Why is that?
Because they will provide a public airing of general corruption issues without descending to specific corruption issues involving individuals. The difficulty is drawing that line between specific issues which we can't do or make the subject of a public inquiry and a general inquiry into vulnerabilities and risks. But I think a general inquiry into vulnerabilities and risks is going to be very valuable in some areas.
So is there any reason that, so what's the reason for not, I guess, pulling that trigger just yet? Are you still undertaking investigations? Have you not concluded, not reached that threshold? I'm just trying to understand.
We are looking at the referrals that are coming in and having them examined by our strategic intelligence team to identify some thematic areas or some recurrent themes, if you like, that we think might be appropriate for a public inquiry. And as I say, we've got a couple of, I think there's 3 or 4 areas in which we're now getting enough of those recurrent themes to suggest that that might be appropriate.
Are you able to share any of those themes?
Broadly, yes. So one involves corruption risks and vulnerabilities associated with the National Disability Insurance Scheme. Another involves corruption risks and vulnerabilities associated with the employment of contractors, particularly contractors in labour hire firms that may then be engaged in effectively hiring their own contractors and expanding the influence that they have in the relevant agency. And the third is corruption risks associated with grant schemes. So they're the three particular ones we're looking at.
Can I just add to that, because I have a special interest in corruption prevention and education. One of the things the Commissioner's talking about with trying to get through the investigations is we're starting to see these things that he's raised as trends and coming up in a lot of those, not just the 4,000 referrals, but things that are actually getting to the preliminary and full investigation stage. What we're waiting for is the outcomes of those investigations so that we can actually use them as real-time case studies and show, particularly because we haven't had a Commonwealth Anti-Corruption Commission before, and we've been using examples from state and territory anti-corruption agencies, that we want to be able to use our real examples and recent investigations to actually show where the risks and vulnerabilities are. So it's just that patience of we're trying to get some of those outcomes of those investigations so that we can actually bring them, the findings out through those public inquiries.
And finding these patterns and themes, using your words, is that to link it to the definition of systemic corruption that exists in the legislation? Is that what you're trying to do there, or you're just making sure you've got...
It's not necessarily tied to systemic, but if we want to have a public inquiry, I think we want to do that into something that is going to have more than an incidental impact on one thing, and the trigger, or not necessarily the trigger, but the sign for a public inquiry, to me at the moment, is if we see an area in which there appear to be recurrent issues or problems, that might well be an appropriate target for a public inquiry.
So that we can identify the vulnerabilities and then raise the capacity in the general public service to look for those vulnerabilities and target harden them. But it's having that real-time data to use that.
Look, I understand public inquiries are rare. In my home state of New South Wales, I think this year the ICAC's only had 2 public inquiries, the year before 4. So it may not be a like-for-like comparison, but I'm just...
There is an important distinction. In New South Wales, a public inquiry is what we would call a public hearing in a corruption investigation, which is quite different from our concept of a public inquiry. So in New South Wales, if we were to hold public hearings in a corruption investigation, that would be equivalent to a public inquiry in New South Wales. But for us, the exceptional circumstances test applies to that. Our public inquiry is quite a different creature. It's more like a commission of inquiry into an issue than a public hearing of a corruption investigation.
In the 35 years of operations of the New South Wales ICAC, they've only done 3 public inquiries as we are describing them.
Right, okay.
2 on lobbyists and 1 on pork barrelling.
Right.
Everything else has been the equivalent of what we would call public hearings.
Okay.
We need to rotate the call, but we can come back to you.
Okay, not a problem.
We'll go to Tony Zapier online. Mr. Zapier, are you there? Okay, we might go back to Dr. Haynes and we'll try Mr. Zapier again in a moment.
Thank you very much, Chair. Commissioner Brereton, there's a couple of things that are troubling me. Could I go back to the initial media statement regarding Robo-debt, where the NAC was announcing the decision not to investigate the Robo-debt referrals? That media statement referred to the following factors. The Robo-debt scheme has already been fully explored by the Royal Commission. The National Anti-Corruption Commission would be unlikely to obtain significant new evidence. There's a risk of inconsistent outcomes and the oppression involved in subjecting individuals to repeated investigations. A corruption investigation would not add value in the public interest. The Commission cannot grant a remedy or impose a sanction, nor could it make any recommendation that could not have been made by the Royal Commission. An investigation by the Commission would not provide any individual remedy or redress for the recipients of government payments or their families who suffered due to the Robo-debt scheme. Is that an accurate summary of the media release?
I think so, yes.
Can you explain to me, please, the basis for the view that the Commission has a role in granting remedies?
There is no view that the Commission has a role in granting remedies. What the media statement was explaining was that we couldn't grant a remedy and therefore we would not be doing something of benefit that could result in benefit to the victims of Robo-debt. We couldn't grant them a remedy.
So given that the National Anti-Corruption Commission cannot grant a remedy, why was that even said in the media statement? I'm really unsettled by this because I think it creates for the general public some confusion that that was the reason or a key reason why Robo-debt was not investigated. And I just wonder if you could take me back to that decision around including that in the media statement.
The decision was to explain that we could not do what a criminal court does, we could not do what a civil court does, and we could not do what a disciplinary tribunal does. And for those reasons, amongst others, we were not going to add value.
Then can I ask you, please, what you mean then, given that what you mean by value and how you would define the public interest in the National Anti-Corruption Commission investigating Robo-debt or indeed any other case, if we all agree that the National Anti-Corruption Commission does not provide remedy, but it's there to investigate corruption in the public interest. What is the public interest?
The public interest is in exposing corrupt conduct that has not otherwise been exposed.
Can I ask you then, Commissioner, why do you think Commissioner Holmes delayed her report on Robo-debt for a week in order to make a referral to the National Anti-Corruption Commission? Why do you think she wanted to make a referral to this commission?
I don't know, and you would have to ask her that question, but my assessment is that, like most royal commissions, the Commissioner would have wished to provide to other agencies that might have an interest information if it was going to be of interest to the receiving agency to act on. But there is nothing in the referral to indicate that a view had been reached that there was corrupt conduct for us to look at. There was a referral of information for us to consider, and that's, I'm afraid you'd have to ask Commissioner Holmes as to why she took that course. But I don't see anything particularly unusual about it because, for example, in the Afghan inquiry, I recommended that matters be referred for criminal investigation. It's then entirely up to the criminal investigators as to what, if anything, they do with it.
Commissioner, I'm still really deeply troubled by this. I'm deeply troubled because at the time of the referral of the Robo-debt case, by everyone's absolutely clear understanding, the National Anti-Corruption Commission was brand new, was being stood up. We've talked about that. In my mind, the National Anti-Corruption Commission is a key part of its role is explaining to the Australian public what constitutes corruption, what is in the public interest when we see potentially maladministration or indeed when we see what was uncovered by the Robo-debt Royal Commission. We've all agreed there could be no remedy, but surely a key role of the National Anti-Corruption Commission is in getting a very clear understanding of what corruption looks like when there is no criminal outcome and when there is no remedy, but when there is a strong public interest in understanding that. I just want you to explain to me, please, where you think the areas of public interest are in the role of the National Anti-Corruption Commission.
I agree with a great deal of what you say, Dr. Haynes, but I think that is best done in cases in which we are exposing and exploring conduct that hasn't otherwise been exposed and explored. And I agree with that we have an important role in explaining what is corrupt conduct and what isn't. I think we've been doing that fairly extensively in our corruption prevention and engagement work, and we are also exploring the boundaries of it in some of the investigations that are underway into matters that have not otherwise been investigated. And that will, the public interest lies in exposing corrupt conduct, but if you're exposing conduct that has already been exposed, that's where I don't think you're adding much value. And we've never said that there is no value in it, but when you look at the balancing all the considerations, the value in simply adding a stamp of corrupt conduct to the conduct that had been found by the Robodebt Royal Commission did not advance the public interest, or would not advance the public. That was our thinking, or my thinking anyway.
Commissioner, can I just check? Did you just say that the Royal Commission had already had a finding of corruption?
No.
No, I thought
No, I didn't. No.
But clearly,
Royal
Commissioner Holmes had concerns that there was corruption.
I think that is, with great respect, entirely speculative, and there is the mere fact that you refer something doesn't mean that you have a concern that there is corruption, but I'm just trying to think back to the material, but I don't think that's a fair conclusion, no.
Commissioner, I put it to you that it would be a fair assumption that most people referring something to the National Anti-Corruption Commission would be doing so because they had a concern that corrupt behaviour had taken place.
I would say that they would do so because they thought that there was material that was worth having a look at.
Okay. Could you also explain to me, please, do you agree that one of the key powers and purposes of the NAC is to make findings of corrupt conduct a finding of fact? And that's important in and of itself. Would you be able to reflect on that for me, please?
Well, I agree.
Could you explain what a finding of fact would be in a case such as Robo-debt, or if you wanted to use another example? What's the finding of fact?
A finding of fact would be a finding that one of the referred persons engaged in corrupt conduct.
Thank you. Can I just be absolutely confident then that you were confident that there would not be such a finding of fact with any of the referred persons in the Robo-debt case?
Absolutely no to your question. It is quite possible, well, I won't go as far as saying quite possible, but the legal advice that we obtained from our lawyers was to the effect that, if proved, the conduct could fall within the definition of corrupt conduct. And we proceeded on the basis that a corruption issue arose, but that for all the reasons given in Deputy Commissioner Rose's reasons, it was not appropriate for us to take further action in relation to that corruption issue in accordance with Section 41.5 or 41.6, I think, of the Act. So, no, absolutely, I'm not going to say by any means that I or anyone else is confident that there was no prospect of making a finding of corrupt conduct, and that was never the basis on which the matter was addressed.
Thanks, Commissioner.
We'll go to Mr. Zapier online.
Tony's there, he's muted.
Yeah. I've been messaging with him and he is there and he can hear us, apparently.
Does he know he's muted, Chair?
Oh, he will do, because we've just said... All right, I'm going to rotate around you again, Mr Zapier. I'm very sorry. We'll go back to Senator Shoebridge.
Thanks, Chair. Commissioner, do you accept that the standards you set as NAC Commissioner send a message to the whole of the public service?
Yes.
And in your case, in relation to Robo-debt, you put in 4 separate notices about a conflict of interest, including that referred person 1 was someone you know well, including that the referred person 1 is well known to me, including referred person 1 was an individual with whom I have had or have a close association, and including the referred person 1 is one of those with whom I have had a close association. Do you remember putting those 4 separate conflict of interest reports in?
I certainly do.
You then, on a high-profile corruption referral, took part in critical meetings about whether or not referred person 1 should be the subject of a corruption investigation by your agency. You crafted a request for legal advice that dealt with whether or not the conduct of referred person 1 and others could amount to corruption. You settled the minutes of the key meeting that was questioning whether or not referred person 1 or others should be the subject of a NAC investigation. And then you then settled the media release about referred person 1 and others not being investigated, and indeed you let referred person 1 edit that media release. You accept all that happened?
Let me deal with it one by one. None of my involvements were related specifically to referred person 1. They related to the referrals as a whole. Secondly, insofar as I was involved in a critical meeting, I was present at the meeting for the discussion until it came time for the decision to be made, and I then left the meeting so that the decision could be made freely in my absence. Thirdly, so far as the legal advice was concerned, yes, as the senior lawyer in the Commission, I was involved in framing the question for legal advice. It's not exactly controversial. It was a question was if the conduct described in the referral from the Robo-debt Royal Commission was proven, would it constitute corrupt conduct? Fourthly, I was involved in settling the minutes of the meeting at which I had been present. And I settled those with others, and I wasn't the only person who settled the minutes. I settled minutes of a meeting at which I was involved. So far as the media release was involved, yes, I was absolutely involved in settling the terms of a media release which would reflect on my commission and in circumstances where the decision had already been made. So that's irrelevant to the question of apprehended bias because the decision had already been made by the time the media release came to be prepared. And as to the suggestion that we let, or that I let referred person 1 or anyone else edit the media release, it is a matter of our practice that before we make a public statement about a matter, the people who will be affected by that are provided with a copy of it and an opportunity to comment on it. And Deputy Commissioner Rose wrote to each of the referred persons, informed them of the decision and of the proposed media release and asked for their, or invited their comments as a matter of ordinary common fairness.
You see, Commissioner, both Mr Robertson and the Inspector both found that the conduct that I outlined amounted to a failure to deal with your conflict of interest, such that now at enormous public expense and at significant damage to the NAC's reputation, you're going through a process of trying to find someone to mark your homework, and another eminent specialist expert to be appointed. And you reject the conclusion of both the Inspector and Mr Robertson that you failed to appropriately deal with your conflict of interest. You reject that, don't you?
I have said that we accept the finding that there was a mistake of law in the way that I dealt with the conflict.
You said you disagreed with it.
I said I accept it, even though
You said you
I
disagreed with it, Commissioner.
I
You said it in this hearing.
Okay, we're not going to
Chair,
talk over each other.
I think I've made my position quite clear.
You said you disagreed with it. Do you want to change that evidence, Commissioner?
I do not want to change my position. That personally I disagree with it, but I accept it because I am used to accepting processes, including being found to be wrong.
You see, public officials at every level are expected to appropriately manage their conflicts of interest, and in fact face the threat of a referral to the NAC if they fail to manage their conflicts of interest. And you've just sent them a very clear message that they can be involved in the discussions, can be involved in requests for legal advice, settle media releases, all the way through the process. But if they just step out at the last minute, you as Commissioner will say they dealt with their conflict of interest, and you as Commissioner will see nothing wrong. And do you not accept that that is a very dangerous message to send to thousands and thousands of public servants who have to deal with conflicts of interest?
I don't accept that that's a message.
Well, it's the message you've given today, Commissioner, in rejecting the Inspector's finding, in rejecting Mr Robertson's finding, and in trying to justify, as you have continued to do, your deep involvement in this matter, notwithstanding a conflict of interest.
I have said that I do not reject the finding. I have said repeatedly...
You disagree with it.
May I complete my answer, please, Chair?
Yes, I have said a few times now, Senator Shoebridge, we are not going to talk over each other. You ask the questions, you work for the answer. We will conduct this in a respectful manner.
I have repeatedly said that I accept the finding, even though I do not agree with it. That means that I respect the process that has been followed, and I am complying with that process and will continue to do so. And I think the pretty clear message from this to every official out there is that you remain involved in something in which you have a perceived conflict at your peril. I would have thought that was a very clear message.
But that message didn't come from you. In fact, the contrary message came from you. That message has only come from the Inspector and Mr Robertson. You surely accept that.
I think it also comes from my acceptance of and acting on the Inspector's recommendation.
You see, Commissioner, you did express a view about the motives of referred person 1 in her conduct in the Robo-debt scandal, didn't you? You did express a view, your own personal view about it, didn't you?
I did not express a personal... What I did in framing the question for legal advice was to make an observation not about referred person 1, but about all of the referred persons generically, based on what seemed to me to be the position from the material I read in the referral. It was not specific to referred person 1, and it was a matter which the lawyers needed to be alert to because that was an important consideration as to whether corrupt conduct would be established when they considered their advice.
Well, let's go to what you said and what you said to the lawyers. You said the complaint is that advice was given and decisions made which at best did not reflect and at worst deliberately concealed that the proposed course of action was unlawful. The motive appears to have been not private benefit, but implementing the perceived will of the government of the day. Whether this type of conduct by public officials attracts the definition of corrupt conduct may be novel. You clearly expressed a view about the motives of a person with whom you had, to quote you, a close association. You asserted that person's motive was not private benefit. How did you know it wasn't private benefit?
I did not express any view about referred person one specifically. I did not express an opinion as to what, let me put it this way, I used the word clearly, appears. That was an appearance from the material that I had read. And that was a matter to be drawn to the attention of the lawyers so that they can... The whole question of motive is crucial to the concept of breach of public trust, and that focused their attention on issues I wanted them to consider.
Commissioner, you are dead right that the question of motive is critical. And you said, and I'll quote it again, the motive appears to have been not private benefit. Now, Commissioner, retaining $1 million job, which is subject to the whims of the government of the day, is private benefit. Obtaining promotion in the public service because you conform to the will of the government of the day is private benefit. Did you know that the decision of referred person one was not motivated by those forms of private benefit? Did you know that?
Of course I didn't know it, nor did I know what it was motivated by, but from reading the material in the reference from the Royal Commission, I formed an impression which I stated.
Yeah. You formed an impression. You said the motive appears to have been not private benefit about a person with whom you had a close association, despite what I think millions of Australians would see is a clear private benefit, a clear personal benefit from somebody on $1 million job keeping their job with the government of the day by complying with their political will. Do you not understand, A, how offensive it is to have the head of the NAC express views about the motives of people who have been referred to them, and especially in circumstances where you said you have a conflict of interest? Do you not understand the problem, Commissioner?
I would have thought that it was incumbent on the NAC to form views about the motives of people. However, you seem to skip over the word appears, which is one of the crucial words in that passage, and that was an appearance from reading the referred material. I'm not instructing the lawyers to assume something, I'm simply drawing to their attention something to be considered, and I did so generically in respect of all the referred persons without specific reference to referred person one.
And we're going to move on.
All right, Chair.
Senator
So
Sheward.
I've got to tell you, there is nowhere near adequate time. But I know you know that, Chair. So
We'll go to Mr Zapier.
Karen, can you hear me?
Yes, Tony, we can hear you.
Thank you.
Please
I'm
go
sorry
ahead.
we've been having all sorts of trouble from this end, but anyway, I have heard all of the evidence thus far. Commissioner, thank you for the answers you've provided today. I simply have two questions, and they really go to process more than anything else. And in your opening statement, and correct me if I'm wrong, I think you said words along the lines, an eminent person will be appointed and the mistake will be rectified, referring to the decision not to proceed with the Robo-debt investigation. Could you explain what you meant by the mistake will be rectified?
My mistake in remaining involved to the extent that I did in consideration of the matter, and the effect that that has had on requiring reconsideration, will be rectified by having the original decision to whether or not to investigate the Robo-debt referrals remade by an independent person. So my mistake will be rectified by having an independent person redo that.
Thank you for that. And in light of all that, and the questions asked by Senator Shoebridge, do you believe that the Act itself should be changed so that the appointment of an eminent person would be made by a party other than yourself in future matters, not necessarily in this one, in all matters?
Look, I think there are a number of amendments that could be made to make this process easier. One of them would be to have something similar to what is in the New South Wales Act, which enables the appointment of an assistant commissioner, an additional assistant commissioner for a specific purpose, and I think that would be a good way to have the potential to address this sort of situation in the future.
Thank you.
Provision,
Thanks, Karen.
Section 6 and 6A of the New South Wales Anti-Corruption Independent Commission Against Corruption Act specifically includes references to where there's conflicts of interest. And that was why it's been used by that institution over time as a way of avoiding having to undertake investigations where there may be a conflict of interest. It's well worth looking at.
Thank you. Mr. Laxell.
Thank you. In the forward, Mr. Brereton, you mentioned as part of 221 cases which passed triage and no further action were taken, some of them had no further action because it would not add value in the public interest, and that reason was one of three reasons that you put in your opening statement. I guess I just want to try and understand what you mean by would not add value in the public interest, because I guess my personal interpretation of that is that, look, in your investigations, some corrupt conduct could have been identified, but it didn't meet, according to the decision made by the Commission, it didn't meet that public interest test. Could you explain how you define how something would add value to the public interest, even though corrupt conduct might exist?
I guess that brings me back somewhat to my answer to Dr. Haynes a little earlier. So if something has already been investigated by another agency, us investigating it is unlikely to add value in the public interest. If something is already under investigation by another agency, even though it hasn't proceeded to completion, it's unlikely that we're going to add value if they've got the capability to investigate it. And another example that I'll touch on is there was one case that I can recall of misuse of information, which could probably have been proved by a public official who was a victim of domestic violence and who was accessing official information for the purpose of tracking her abuser. And we didn't think it would add value in the public interest to open a corruption investigation in those circumstances, even though it fell within the definition of misuse of information.
Okay. That's all the questions I had in regards to that. Thank you, Chair.
Thank you. We will go to Dr. Haynes.
Thanks very much, Chair. Commissioner Brereton, it was new information to me in your opening statement that there's been private hearings as part of 7 investigations featuring 26 people. Did you consider at any point with those investigations that there were exceptional circumstances that might merit a public hearing?
In each one of them, we consider whether there are exceptional circumstances, and in none of them did I consider that there were.
Are you able to explain to me just the questions you ask as a commission around what would meet the test for exceptional circumstances in such cases?
It is really hard to lay down in advance what is going to be exceptional, what takes something out of the general rule, and I've said from day one that we'll know exceptional circumstances when we see them, but you can't lay down in advance this will be and this won't be. But some of the considerations would be, is there a high level of confidence that corrupt conduct will be established? In other words, you wouldn't want to do it if there was still a significant degree of uncertainty as to whether you would get to the point of corrupt conduct. I think the prominence of the person of interest and their position will be a relevant consideration, because if the investigation involves someone in a high public office, that might make the circumstances exceptional. Similarly, look, and I think they're probably two of the considerations that we can put our fingers on now. But just because you're in a high public office doesn't mean that there should be a public hearing, at least if there's not a high degree of satisfaction that there'll be a finding of corrupt conduct.
Amongst those 26 people, are you able to tell me if there were parliamentarians, contractors, what kind of category public servants the people came under?
Contractors, public servants, I can say no parliamentarians yet.
What do you mean by yet?
Exactly that.
So those investigations are ongoing.
Yes.
Yep. You mentioned before that if it was a person of high public office, that would weigh into your consideration of exceptional circumstances. Can you tell me why?
Because part of the test is public interest, and public interest there is public interest in knowing if there are provable allegations of corrupt conduct concerning a person in high public office.
Would it help, Commissioner, if our legislation was more explicit about exactly that the exceptional circumstances test would include such a category?
I honestly don't think that legislation that specifies a whole list of factors to be taken into account really helps. I think, sometimes I think listing factors tends to confine the decision making rather than making it more more open to a wide range of discretionary considerations.
Could you just take me into the room when you are considering investigations that are on foot, about at what juncture you might pause and say, I think we're there, I think we need to have a public hearing? How would that take place?
So each time I issue a summons, and as I say, I think there have been 26 so far, I think, are we at the position to have a public hearing? And the answer so far has been none of them have crossed the exceptional circumstances line. If there are a couple of investigations on foot at the moment that could potentially get there, but I'm not going to, it's not appropriate to go into more detail about them, but there are a couple of investigations that could lead there. There are also other considerations concerning witness welfare and the like, because we need to be conscious of the impact our activities have on witnesses, and we need to take that into account too.
Thanks, Commissioner. Chair, can I have one more, perhaps?
Sure. Okay.
Sorry, everyone, we're going to run late. Sorry to the inspector who's waiting. Sorry to Broadcasting and Hansard.
It just goes to transparency of the activity of the National Anti-Corruption Commission, and of course, the nation is curious around what's happening. Are you able to tell me how many reports have been tabled with the Attorney General thus far?
none of our own, because none of our investigations have been concluded. One from Ackley Matters, and the committees, we provided to the committee a version of that. But in terms of transparency, Dr. Haynes, if you or the committee or anyone else has any ideas on things that we can do without compromising the integrity of investigations, we are all ears and interested in doing that.
Thanks, Commissioner. I know we have given you some feedback and your website has provided more information over the course of the year and a half that you've been operating. I did notice there was a change to the website which has a new section called misinformation. I'm curious why the Commission felt they needed to do that and whose idea that might have been, what the purpose of that was. I
think the suggestion originally came from our media people, but the reason for it is that there has been misreporting. I referred earlier to, for example, the Operation Bannister matter. There was some misreporting about that, and we thought it important to clarify that, and we're using that as an opportunity to put right some of the incorrect rumours or stories that are run about us.
Thanks, Commissioner.
Thank you. We'll go to Senator Shoebridge, hopefully for 5 minutes or less.
All right, thanks, Chair. And I too apologise to keep the inspector waiting. Commissioner, you agreed that you sent out the media release about the Robodebt decision. You agreed that you settled the media release?
Yes.
Yep.
Well, I was involved. I was involved with others in settling the media release, and I certainly take responsibility for it.
The final version was approved by you.
Well, I just said I take responsibility for it.
I heard you, but I'm putting to you the final version was approved by you. Is that right or wrong?
I'm sure it would have been.
All right. And the media release said, amongst other things, there is not value in duplicating work that has been or is being done by others, in this case with the investigative powers of the Royal Commission and the remedial powers of the APSC. Do you remember agreeing to that being in the media release?
I don't remember specifically agreeing to it, but I did.
At the time that you issued the media release, there were no such remedial powers that the APS, the Australian Public Service Commission, could exercise in relation to the 6 referred persons, were there?
The point that we were seeking to make was that we didn't have the disciplinary powers that the APSC had, we didn't have the remedial powers that a civil court had, we didn't have the punitive powers that a criminal court had. Generally, the APSC can impose sanctions. Unfortunately, in stating that in the context of this case, that gave the impression that it could imply sanctions in the present case, when it couldn't, because by then all the public servants had left the APS. It was not our intention, it was not my intention to convey that impression, but I accept that that was the effect. As we said in our submissions to the inspector, that was unintentional and we are sorry for it.
Well, you see, Commissioner, it wasn't just an impression, because you went further in your media release and you said, and I quote from your own media release, "The Commission cannot grant a remedy or impose a sanction, bracket, as the APSC can." That's not an impression, that's a statement. And you made it twice. And it was wrong and it was misleading, wasn't it?
The statement that the APSC can impose a sanction is correct. The impression that it could impose a sanction in this case was misleading, and for that we have apologised for the unintentional misleading effect.
This was a media statement about this case and about the 6 referred persons, and twice, you put in your media release directly misleading statements that you must have known were false at the time. Will you apologise for that?
I have apologised and you have just heard me repeat the apology for the statement. The suggestion that I must have known they were false at the time is offensive, and I reject it.
You knew that
So,
they had
Senator
left
Shoebridge,
the public service,
Senator Shoebridge.
Commissioner.
As opposed to placing statements and accusations, if you could just restrict yourself to asking questions, the standing orders do take us to not undertaking that sort of behaviour.
Commissioner, you knew at the time the media release was issued that they had left the public service, those who were in the public service, or they had never been a member of the public service and then were never subject to the remedial actions of the APSC. You knew that, didn't you?
I do not believe that I knew that all of them had left, although I certainly knew that most of them had. I did not, at the time of approving that release, turn my mind to that factor.
Commissioner, we unfortunately have run out of time, but could I ask you to take a couple of things on notice? Can you please provide all the records of correspondence between Deputy Commissioner Rose and the APSC on the subject of the Robo-debt referrals? And whilst we're on matters to take on notice, can you inform the committee whether or not you communicated with the APSC about the decision not to investigate referrals, and if so, why you did?
So, as to the...
You were just asked to take it on notice,
Well,
Commissioner.
I can-
We are finishing up.
If you're able to briefly address it now.
I can answer the second question now, that the only communication I had with the APSC was immediately before the publication of the media release, when I informed the Commissioner of the APSC that we were going to announce that decision the following day. As to the first part of the question, we will, as requested, take that on notice.
And you will explain on notice why you, rather than Deputy Commissioner Rose, who you say was the decision maker, informed the APSC about that.
The decision had been made. It was a head of agency to head of agency courtesy communication.
And I'm sorry to just, so it's not addressed narrowly, if there's any other correspondence that's come from any other officer of the Commission or the Commission more broadly to the APSC in relation to the Robo-debt referrals, could I ask you also to provide that on notice?
Senator Shoebridge, if you're concerned about getting the accurate information you're looking for, perhaps you would want to take a moment to just write down the scope, if that's
I'm
open to you if you want.
if the Commission will agrees to take that on notice.
We'll do that.
Great. Thank you. That concludes today's hearing with the National Anti-Corruption Commission. Thank you very much for coming along and spending some quality time with us. We will let you go, and the committee will take a short break, and we will return at 2:45 with the inspector. Thank you. everybody but me, that is. Okay, I now welcome Ms Gail Furness, the Inspector of the National Anti-Corruption Commission. You have received information on parliamentary privilege and the protection of witnesses, I believe.
I have, thank you, Senator.
Excellent. Can you please state your full name and the capacity in which you're appearing before us?
My name is Gail Barton Furness and I'm the Inspector of the National Anti-Corruption Commission.
Thank you. I would now like to invite you to make a short opening statement.
Thank you. As the members of the committee know, I provided a copy of that this morning, and given the time, I propose to give an abridged version, if I can, of that statement.
Thank you.
That would be great. We can accept it for tailing.
Yes, we have accepted it and we will publish it as well.
The NAC Commissioner must refer to me any NAC corruption issues that he becomes aware of as Inspector. During the reporting period, 2 NAC corruption issues were referred, and they're set out as section 7.3, page 8 of my annual report. And I won't read them, but invite the committee to read it. For the 2023 to 2024 financial year, I received over 1,300 contacts. As at the end of the financial year, 1,164 were in relation to the decision not to investigate referrals from the Royal Commission. 50 were more general complaints. About 85% of those 50 more general complaints were complaints that the NAC did not investigate the concerns of the person referring a report to them. 7 complaints were made about the service standards that the complainants said they received when making a referral. Most of those concerned timeframes in which the NAC responded, having regard to its published guidelines. That is, they didn't receive responses in the time indicated. There were 2 complaints, other than the Robo-debt referrals, which I considered could amount to maladministration. They are set out at section 7.4.1, pages 9 to 10 of my annual report, and I give some detail as to those complaints and why I ultimately did not form the view that they amounted to maladministration. Now, there were just 2 matters that arose this morning, factual matters that I thought I might be able to assist the committee with. The first was the reason for the referral by the Royal Commission, and if I can refer to my report, October 2024 report, in the introduction on page 6 of that report, I quote from the Honourable Holmes what she said in her letter seeking an extension in order, as we know, to provide the referrals. And she said in that letter that she sought a short extension in order to refer individuals to the National Anti-Corruption Commission should she reach the view their conduct may meet the definition of corrupt conduct under the NAC Act. So that's the closest I have to her thinking in relation to that matter. Secondly, there was a question as to the legal advice that was provided by the Commission's internal lawyers, and I think that the Commissioner, without any record in front of him to refer to, indicated that the advice was it could constitute corrupt conduct. The advice was that it would constitute corrupt conduct, and I refer you to Mr Robertson's report at paragraph 56, where he quotes from that legal advice.
Thank you, that's very helpful.
So I welcome any questions from the committee.
We will go to Dr Haynes.
Thank you very much, Chair. Thank you very much, Ms Furness, for your annual report and for appearing before us today. I guess there's a lot to unpack. This is the first year of the National Anti-Corruption Commission, and it has been most extraordinary that we, as a nation, have required the services of the Inspector based on considerable numbers of complaints, as you've indicated in your annual report, in regard to the National Anti-Corruption Commission's decision on the Robo-debt. Could you speak to us, please, about your decision-making process in determining when you look at the volume of a complaint or the content of complaints, and how that influences your decision to go ahead and do the investigation which you subsequently did?
Well, in this case, I received 700 complaints within about 3 days of the decision being published by the Commission, and then that is now over 1,200 complaints. So when it reached 700, I think it's fair to say that I knew I had to inquire into it, because there would be no way I could write to 700 people saying there was nothing to see here without me looking to see if there was anything to see. So the sheer number was sufficient for me. The nature of the complaints, which particularly resonated with me, because as you know, I don't have a merits review jurisdiction. My jurisdiction is set out in the Act, was the conflict of interest, which was raised by a number of people, and the terms of the media release. They particularly generated my concern, given the nature of my jurisdiction. In my experience of complaints, which goes back some time, I don't think I've ever received or heard of that number of complaints being received about the same matter in a way that they were not automatically generated. So it was not a difficult decision, Dr. Haynes.
Thank you, Ms Finesse. Could you define for the committee what you would consider is public interest? I think that would be helpful.
Well, I certainly think that the public interest in the NAC is in it detecting and exposing corrupt conduct. Of course, there are other education and corruption prevention functions under the Act. However, as I think Mr Brereton indicated, there is an integrity framework in the Commonwealth, and various people play various parts in terms of the APSC giving general advice and the other components of it. What the National Anti-Corruption Commission has that the others don't have is making a finding of corrupt conduct. So that's why I say detecting and exposing corrupt conduct is particularly with respect to the Commission, its functions and its role in relation to the broader integrity framework.
Ms Finesse, the finding of corrupt conduct without remedy, could you just explain that? I know there's a lot of people listening to this hearing, and I think it's important to understand why a finding of fact of corrupt conduct matters, even if there is no criminal conduct or some further remedy that could be addressed to that conduct.
Well, I might, if I can, in answering that question, have regard to my other hat, which is as Inspector of the Independent Commission Against Corruption in New South Wales.
Yes, please.
That body doesn't and never has, and has never sought, as far as I'm concerned, certainly in more recent times, any power other than to refer for consideration to the DPP if they think there may well be some criminal conduct. But generally, they make findings of corrupt conduct. They consider that to be their role, and I consider that there's public benefit in a finding of corrupt conduct based on my experience with the ICAC and my understanding of how they work and the results of their work.
Thank you. Can I ask you, in your deliberations in addressing the complaints and you subsequently making the decision to undertake an investigation into the National Anti-Corruption Commission processes around the Robo-debt decision, what steps did you take? How did you determine who your legal advice would come from and the subsequent appointment of Mr Robertson?
Well, it became clear to me very early on that I needed assistance because, as you may well know, I am in a part-time role and I'm assisted by a very able director and a very able administrative officer, but I'm small. So I engaged Trent Glover, as he then was, he's now senior counsel, to assist me. And when it became clear to me my views as to the management or otherwise of the conflict of interest, I was acutely conscious of the seriousness and ramifications and believed that the public interest would be best served by me engaging a administrative law expert and very well regarded former federal court judge as to his view of the material. So that's part of the answer. The other is that I asked the Commission to provide me with everything they got from the Royal Commission, everything they considered, and any material they generated effectively as a result of their work. I also asked them to provide me with a chronology because I simply didn't have the resources, and they did, and they provided me with a detailed chronology hyperlinked to many documents. So it was reading that chronology, some of which is set out in Mr Robertson's report, some of which is set out in my report, that gave rise to my concerns, and I then engaged Mr Robertson.
Ms Finesse, could you tell us, in regard to your dealings with the National Anti-Corruption Commission, as in your role as the inspector and under the express purpose of the investigation that you sought to undertake, how would you describe the cooperation of the National Anti-Corruption Commission in regards to your role?
Well, they certainly provided me with an awful lot of documents, and they provided me with the hyperlink chronology, for which I was grateful, and they provided me with further documents as I sought them.
Thank you.
Just a bit of a follow-up, really. The Commissioner has stepped out for us that it's perfectly normal for judges to be found incorrect, and that this issue of his conflict of interest is really not a matter for deep concern. What's your view, Ms Finesse?
Well, I think my view's reflected in my report.
Okay. Thank you. Senator Shubridge.
Oh, thanks, Inspector, and thanks for your work. It was probably busier than you anticipated when you put your hand up, but I think we're all collectively grateful for your work. When did you get the first referral about the Robo-debt matter? Do you remember roughly?
Oh, it would have been, if not hours, certainly within a day or so. I got them very quickly.
And then you said it fairly rapidly got to 700 referrals. And do you remember when it was you determined to start your investigation?
Look, I think it's in the report, but I think the Commission announced its decision on about the 6th of June, and I announced mine on the 13th of June. So I think it was about a week. And then on the 14th, I met with the Deputy Commissioner Rose at her request and explained the themes of the complaints I had received and indicated what I wished her to provide me, or the Commission to provide me. And the following day, or indeed I think it might have been that same day, I sent a letter confirming the request. And then I was provided material in tranches, and the dates of that set out in the report. I think I received the final material by about mid-August, but the dates are set out in the report.
And I know Dr Haynes asked you some questions about that, but from your perspective, was the Commission providing you with timely and adequate access to the information you needed?
Yes, I mean, it was timely in the extent that they said they couldn't do it more quickly. I always would like things more quickly, but I'm sure they did their best.
And then you got the last tranche of evidence in about August, and then you engaged, was that when you engaged?
No, I'd engaged Mr Robertson earlier than that, and I certainly had engaged Mr Glover earlier than that. I'd engaged Mr Robertson, from memory, before I received the first submissions, the August submissions, but he obviously had them for the purposes of his report. So I engaged him when I had formed my own view reading the material I had.
And the NAC in its initial submission, I've got it here in front of me, paragraph 36, said this section of the submissions addressed aspects of the decision-making process the Commission understands may be relevant to complaints made to the Inspector. you've advised they raise the following themes, and there's 4 dot points. How the perceived conflict of interest of the Commissioner was dealt with, the time the Commissioner took to make its decision, the sufficiency of the Commission's reasons for its decision, and the failure of the Commission to investigate as a breach of public trust. Is that that's a fair reflection of...
Yes, that's a fair reflection.
And then you got the report of former Justice Robertson on the 30th. It's dated the 30th of August.
I got it on the 30th of August.
And then you provided that to the NAC for them to make further submissions?
I completed my report, which incorporated or accepted and adopted some of Mr Robertson's findings, but also dealt with the extra issue of the Public Service Commission reference in the media release. And with the benefit of Mr Robertson's report, I completed my draft report, and I referred my draft report and Mr Robertson's report to the Commission on, I think, the 3rd of September. So that contained the major finding, as well as the recommendation that it be delegated to an appropriate person.
And then the NAC came back to you with part 1 and part 2 of two further tranches of submissions in October.
Yes.
And then you delivered your report. Mine just says October 2024.
I think it's about the 30th.
Yep. So from beginning to end, it's barely 4 months that you had with it.
I'm sure your addition is accurate, Senator.
I mean, I suppose I just wanted to reflect upon the efficiency with which you dealt with it. Incredibly complex matters. You established a process, and from beginning to end, you completed a process within 4 months. With, from my observation, an incredible amount of thought and integrity. And and hearing from you as it went through, I mean, our job is to oversight your work. From my point of view, I just want to commend you on the thoroughness and manner in which you did it, because it was a matter of extreme public concern, and having it dealt with rapidly, for my part, is a credit to your office. So
thank you.
I want to put that on the record. Did you feel you always had adequate resources to deal with it?
Yes, because I engaged Mr Glover and Mr Robertson. I needed to engage them.
Well, but the question of their engagement, did you have to negotiate for any additional funding for that to happen?
No.
Was it within your funding remit? How did that work in terms of the funding?
I knew I had sufficient in my budget because I had underspent on staffing and various other things. And so I knew I had the money, but I wasn't sure precisely how much I'd need, but I knew I had at least some of it. And I approached the Chief Financial Officer of the AGD, and he immediately said I'd have whatever I needed.
All right. And in terms of us being satisfied that you have the financial independence to do your work, are you satisfied you have the financial independence to do your work as needed?
Absolutely. Yeah. Subject to matters such as overheads, which I have to pay, and staff entitlements and the like. I have divisions within my budget for various things, but I can move money within those divisions.
Right. And can I ask you what the budget setting process is that you have? Is it I'll just ask you to describe from your side how the budget's set.
Well, I was obviously consulted before the initial budget was set, and I had a significant role in splitting up what I might need in different divisions, if you like, and was perfectly happy with the amount, which from memory was over $1 million, maybe 1.3. And as you can see, I'm a very small operation, and with my New South Wales hat on, I have an office in New South Wales, and there is an arrangement whereby the Commonwealth pays the state a small amount of money, so I sit in the same office for both purposes. So I don't have much by way of overheads.
You just move flags, do you, as you move?
Well, actually, I move laptops. I have one laptop here and then I have another laptop there.
And in terms of setting the budget for the next financial year, is there a process? Do you know what that process will be over the next few months?
I think it has been set, actually. I think I know what I've got. There's no question of the Attorney General's Department, in particular the Chief Financial Officer, engaging with my staff and myself, and I have never felt and don't anticipate I will feel any constraints in terms of having the resources I need.
All right. Thanks, Inspector.
Thank you. I'm interested to know whether, I know it's quite early on in the piece, really, but if there are any trends that you're seeing in terms of the complaints that are coming to you. Obviously, the Robodebt, if you sort of take that over to one side and from what's left, any trends that you think might be worthy of us understanding?
Well, not surprisingly, in the first year, the Commission received 3,000 odd referrals. But just to put that in context, that was fewer referrals than the ICAC received in the same year. And I think fewer than IBAC, but I'm not sure about that, but certainly fewer than the ICAC received. So not surprisingly, the concerns expressed to me were about the intake and triage process, and there were certainly a lot of teething issues. People couldn't contact the Commission. There was a web form they had to use, but they didn't get a copy of the web form, so they'd come to me and I'd say, well, I'll have to go to NAC to get a copy of your complaint to it. So that's an obvious trend. It's obvious that that's what I would get. But again, with my other hat on, I anticipate as the Commission becomes more operational, the nature of the complaints to me will reflect that. So the trend is intake and triage, generally speaking. They didn't investigate my concerns, and I wish they did, and they should have.
Fair enough. Yes, we also, as the committee, we get quite a lot of incoming.
Yes.
Dr. Haynes.
Thank you very much, Ms. Vaness, and I'd like to add my commendation alongside Senator Shoebridge on the speed and accuracy and quality of the work that you've undertaken.
Thank you, Dr.
In your role. Thank you. Can I just take us back to Robodebt for a moment? I'm curious about the recommendation to appoint an eminent person to relook at the decision making. There's a couple of things I need clarification on. Can you just plot out for me just the timeline of you making that recommendation, whether that was the draft report went to the Commission, I understand. Who announced what? I mean, whose decision ultimately was it to go down the road of appointing an eminent person?
Well, I made the decision to make the recommendation, and that was because in terms of legal principle, which is to have some application, normally when a decision is set aside, if you like, then someone has to make the decision. And clearly someone had to make the decision. In my view, it couldn't be the Commission as it was then involved in the decision making. So it had to be someone else. There was a provision under the Act for that to occur, and so I recommended in the draft report, which I sent on the 3rd of September, that the Commissioner delegate it to an appropriate person. And I've never changed my mind after that. And certainly in their response, I think, from memory, either the 8th of October, I'm not sure which set of submissions they effectively accepted it, but it was, without question, accepted. And then I suppose I think it was the late October, 28th maybe, submissions. It was first stated that they were not waiting for the end of my inquiry, but had decided to appoint an eminent person. Eminent was their word, not mine. And then I reported on the 30th of October, and I think in a minute or two, the media release popped up, which indicated the same thing, that they had independently determined, without waiting for my investigation to be concluded, that they would appoint an eminent person. That's the time frame.
We had some deliberations earlier with the commissioners about the process of appointing an eminent person or an independent person to relook at the decision making around the Robo-debt case. Have you got any reflections with your understanding of the Act about how that process should take place?
Well, it's not straightforward, as it is in New South Wales with the RCAC. The understanding I have is that they are going to go down the path that I think the Commissioner indicated, that is, the CEO appoints somebody at an SES level and then the Commissioner delegate to that person. And I have been consulted in that process recently, and my view is it's really a matter for them how they technically do it under the Act. My concern is of principle and consistent with the report, that however they do it, there is no input from any of those involved in the decision-making process within the Commission to that person.
And how could that possibly be achieved?
Well, the Royal Commissioner provided a sealed section and also provided letters in respect of each of the 6 people, and there's a public report. So if the question is, should the Commission undertake an investigation into any one or any more of those referrals, that decision can only be based on the referred material. So it seems to me that receipt of the 3-volume report, the sealed section, the letters, should be sufficient. But it may well be there's complications I haven't thought of, but if that's the basis of the decision, it seems to me that material can just be given. But I might be missing something.
I doubt it.
Clarification.
Yes.
Ms Venice, did you hear the Commissioner's evidence that they were given a list from the Solicitor General of potential people, of potential applicants?
Just one thing, I think it was a list from the Australian Government Solicitor.
They were given a list from the Australian Government Solicitor. There was some testing, I think, by the Australian Government Solicitor as to whether they would be willing and available to do the work, which narrowed the list down. And then, if I remember correctly, the Commissioner then said that he and the Deputy Commissioners were discussing who from that list.
That's the evidence I heard.
Yeah. Does that accord with your understanding of does that accord with your understanding of an appropriate process, or the process that was agreed?
The person to be selected would have to be a person accepted universally as being of sufficient standing and intellect to carry out the position. So to me, it doesn't trouble me that there was more than one person, particularly of that decision-making panel, if I can refer to them that, involved in determining what person, because it is that person, by virtue of their standing, that will be making the decision, and they will be making it independently. So that's the first point. Secondly, as it appears to me, the only material that person needs is the report and the sealed section and the letters. So if that is the case, then I don't know what any briefing would look like.
So can I just being that this person is not being asked to investigate or to review the NAC per se or how they went about anything, it is just to redo the decision.
As I understand it, that was my intention. As I understand it, someone appropriate will be appointed. That person will then, independently of the Commission, other than receiving the material, come to their own view and express it.
Just two points. One is, part of my question was directed at whether that decision about choosing a person being a decision collectively of the Commissioner and the Deputy Commissioners in the way described has any concerns for you about potential conflicts of interest, or if there was an alternate process considered. But my second question is, yes, there is the referral from the Royal Commission, but as I understand it, there are a whole number of other referrals to the NAC about the Robo-debt outside of, or complaints to the NAC about the Robo-debt Royal Commission outside of the Royal Commission's reference, and whether or not that they are caught up in the same.
Dealing with your first matter as to the process, I can understand the point of view that those engaged in the first lot of decision-making not be involved in choosing the person. I can understand that. It's an available position. Practically, for me, that person will inevitably be of such standing that I would expect that person not to, deliberately not to, engage with any one of the first decision makers.
And that's the ultimate test, to use the word that's used, eminence, if you like, the standing. That's, for you, pretty much the test.
Yes, yes. In relation to your second point, there were other complaints obviously made to the Royal Commission, but as I understand the process they followed from reading the materials...
Sorry, you said Royal Commission.
Sorry, other than the Royal Commission.
Yeah,
so
there are other
received
complaints made to the NAC.
other than the Royal Commission. But as I understand their process from reading the material, that they were primarily concerned with the 6 referrals from the Royal Commission. Yes, because if one looks at the various minutes and notes that are set out in Mr Robertson's report, one will see that it's concentrating on those 6 people.
Yep, sorry, Helen.
You done?
Oh.
You done? Yep, go ahead.
Just, you helpfully, Inspector, made reference to your introduction in terms of the only evidence you had about why the Royal Commission had referred the matter to the NAC. And I've just gone back and reviewed it. And it says on 24 April 2023, the Royal Commissioner, Catherine Holmes, sought a short extension in order to refer individuals to the National Anti-Corruption Commission under Section 6P of the Royal Commissions Act, should she, and then the quote is, reach the view their conduct may meet the definition of corrupt conduct under the National Anti-Corruption Commission Act 2022. And you reference the Royal Commission's report. Is your understanding Ms Holmes got the extension of time and then did refer?
As a matter of timing, yes. I don't know what was in her mind, but as a matter of timing, she sought it on the 24th of April and referred it on the 3rd of July.
And she said that she sought the extension so that if she formed the view, if she reached the view their conduct may meet the definition of corrupt conduct, she would be able to refer them.
Well, that's a quote from her letter.
And one inference from that is a fairly, obvious inference is, therefore, she, having referred them, she most likely did reach the view that the conduct may meet the definition of corrupt conduct.
That's an inference that could be drawn.
Yep, thanks.
Thank you very much. I think we are done.
Thank you.
We do appreciate your time.
Thank you.
It's very valuable for us to have this time to look into your operations and understand more fully what you're up to and how the NAC is progressing. I'd like to thank Hansard and Broadcasting and the Secretariat, and we will now adjourn.
Thank you.
Thank you.